Joining us to talk about this, one of the country's top constitutional experts, senior advocate in the Supreme Court, and over the next several minutes I'll be joined by experts cutting across different spheres, different inclinations in terms of their political and judicial views. So I want to welcome Aryama Sundaram first. Thank you very much, Mr. Sundaram, for joining us. Should content on YouTube be regulated? It's a matter of a big debate. You're seeing what's playing out. The Supreme Court clearly seems to think there is a case for YouTube content to be moderated and regulated. Do you agree? Aryama Sundaram.
Look, first of all, let's take it in perspective. Let's take in perspective what the Supreme Court has done. It's pure and simple. A person who makes a comment and becomes a public figure and does things in public can either get accolades or brickbats for what he has said. Now, he said what he did, which I may personally feel is absolutely prudent, was absolutely objectionable, and I found it something which I would have wished something like this had not been said. Having said so, the answer, of course, was that a person like me would come out and criticize what he has done. Instead, there are various charges framed against him, many of which, according to me, do not apply, except for one, which is under 294 of the Erstwhile Act, which is any utterance of words which can be considered obscene. Unfortunately, obscenity itself is a very subjective thing. We don't know what is obscene, what is not. And it's a bit of subjective thing, although in some sections they try to give a deeming provision. It's a gray area. So that's so far as the case is concerned. Now, what came up before the Supreme Court today, basically, was this man came to court and said, there are a lot of FIRs against me. Please centralize the FIRs, number one. Number two, please protect me from arrest. And number three, let no new FIRs be filed against me on the same issue. All three of which he got from the court. But while he got it from the court, he also got a lambasting for the court for what he had said. Now, same as he quoted his view, I may lambaste him on television for what he had said. The judges were also in a public forum, and they lambasted him from that public forum. The whole difference is when I lambaste him on the television, it's a public comment on a public comment. Whereas when the judges do it, it starts getting the signs of a judicial comment. Now, that's where I'd like to draw a clear distinction. Much of what you had said is not the order of the court, but regulating the IT, doing everything else. These are observations which have come
No, but
up.
Let's come to the real substance of this.
One is complete what I'm saying.
Okay, go on, sir.
Time and time again, we find a lot of observations being made from the bench. Now, many people may feel the court should not have made such observations from the bench. Maybe the judges could have said so somewhere else, but not from the bench. Others may feel the judges were hearing a case and considering whether it was obscenity or not, and whether it will fall within or not, and express their view that it was obscene. Now, that is so far as the case is concerned, and the court has not, other than verbal observations, passed any kind of directions or anything so far as IT regulation is concerned. So if you want, I'll continue on what I feel.
Let me frame the question and then you can give us your answer. I want to quote what Justice Suryakant says. There was the case of YouTubers. We're not going to leave this vacuum the way it is being misused by so-called YouTube channels. Goes on to say, and he's asking now the Attorney General and the Solicitor General to assist in addressing the vacuum, stating if the government of India is willing to do it, we will be happy. Otherwise, we are not going to leave this vacuum. Now, this is being linked to the government, in any case, working on the broadcast bill and the plan to try and regulate YouTube content creation, which a lot of YouTubers feel is really an effort to stifle their free voice. So the two cases have now got linked, and naturally, when the government's already working on this is the perfect opportunity to go in and make that case. Do you think that is warranted? Do you think it's about time that we try and moderate and regulate, like we do on television, what goes on YouTube?
I think you've raised a very important issue. This is actually going to the root of the matter. This is a view expressed by a bench of the Supreme Court without passing any directions, but it's a view expressed by them, which tomorrow, it's a view expressed today. Tomorrow, a court hearing it may or may not continue with such view. Now, according to me, let me deal with it constitutionally. The right to freedom of speech can only be restricted as found in Article 19.2. Your right is under 19.1a, and your restriction on this right is found under 19.2. If it does not fall within 19.2, you cannot be restrained. Now, in India, unfortunately or needfully, pre-censorship has been accepted in any kind of audiovisual content. And this has been recognized by the Supreme Court more than 40 years ago. So in India, we have pre-censorship, which in many other countries like the United States, you do not. But in India, we recognize, especially under the Cinematograph Act, there is pre-censorship. Now the question is this: if there can be pre-censorship on a cinematographic film, the YouTube is also a visual. So the next question which will be asked is, can there not be pre-censorship even so far as content on the YouTube is concerned? Which is where we have to draw a very, very thin line. And that is this, that pre-censorship where vulgarity, obscenity in cinematograph films is allowed. Not where opinions, where views, or even if you say the most unpopular thing, even if you advocate something which the Constitution protects, because there was a famous case of Rangarajan versus Jeevan Ram, where the film was anti-reservation. And in fact went to the extent of saying, these are laws made with flaws. And when the Madras High Court banned it, the Supreme Court reversed it and says freedom is for the thought that we hate, not for the thought that we cherish. And said that that kind of censorship was not permitted. Now, if YouTube content is sought to be censored, I believe that is a very difficult space to go, because a cinematograph film is something very easy to censor. You see the content, see if something is vulgar or obscene, and you direct the cutting of that. But in a YouTube, unless it's a matter of vulgarity or obscenity, visual obscenity or vulgarity, I cannot see how it can be actually censored. Secondly,
what about regulation? So this is pre-censorship.
Censorship has to be done by the state, not by the court.
Sure.
So the court saying that you should bring in some guidelines is going back to the Vishaka principle, where guidelines are meant to be laid down. If there are no guidelines, that vacuum can be filled. So the court is basically saying, you need to lay down certain guidelines, but till that, you need to lay down a law. Till then, we will bring in guidelines. Thus far, all right. But the question is, can the government itself censor speech unless it falls strictly within 19.2? If the government cannot do so, the court also cannot do so by guidelines. So the court cannot do something by guidelines. Any kind of restraint which is not found in 19.2. So at best the court could say that you must have pre-censorship of cinematograph material which comes out on a YouTube because of vulgarity, obscenity, because that's already something which can be done. But to say you must watch what is coming out, you cannot do so unless 19.2 is attracted there. The material must be against public order. Material must be against the integrity of India. The material must be against the sovereignty of India. Material must be something highly defamatory of a nature, which anyway YouTube does. When something is found to be defamatory, there's a mechanism by which it is taken down. So I believe when the court is saying lay down this, what the court says is, to the extent the Constitution permits, if that is not done, till it is done, we will lay down the guidelines.
Sure.
Whether that actually be done is a different thing, but that is the way I understand what the court would mean. But they cannot lay down any rules curbing free speech unless it falls within 19(2) of the Constitution.
Aryama Sundaram for taking out time and joining
Neither
us
the government nor the court can do it.
with your views. Thank you very much. That's Aryama Sundaram.